Before I begin, I just wanted to say that I'm on record with much of what Anthony has said. That is to say that the 14th Amendment's language is clear in covering the children of unauthorized migrants born in the United States. I also want to co-sign what Jessica said, that this executive order, if it were to be enforced, would create all kinds of problems that are better off avoided. What I want to do with the time I have is to talk about this particular decision, though, this decision that ends or purports to end universal injunctions, but also has the effect of ducking the merits of this question. Here's what I want to do is I want to try to talk about it against the backdrop of two dynamics. One is the rise of judicial supremacy during the 20th century. And second, to think about the effect of this ruling in terms of constitutional politics, especially in an age of populist presidents. So first, I think we have to think about the order here and the issue of injunctions against the general rise of courts playing an active role in democratic life. This is a problem, that is to say, at least the problem of judicial supremacy, not just for conservatives and libertarians, but also for progressives who should see that judges don't have a consistent or coherent theory of democracy, even when they do choose to act, and that judicial review is often deployed selectively to strike down popular laws and to create doctrinal obstacles to democratic organizing. Second, when we think about the populist leaders that are in power, but also the ones who may come to power down the road, they come in more than one flavor. So a maximalist belief in judicial review, too much worry about courts not having all of their tools in front of them, this belief itself empowers unelected judges to block the policies of not just a right-wing populist like Trump, but also future populist figures on the left who may emerge down the road. So our criticism of particular decisions like this one and our hope in the courts, I think, should be tempered by our history and any belief that you have in democracy and constitutional politics going forward. Because history shows us that deep constitutional questions can't be solved through judicial orders or universal injunction. Furthermore, judges cannot stop a populist president. They can only do two things. One, they can help clarify the democratic stakes of certain disputes. And two, they can buy time for alternative politics to assert themselves. In terms of this decision, as Jack Goldsmith of Harvard recently noted, it's not clear that the decision is, unalloyed good news for executive power. But what it does do, it accrues more power to SCOTUS at the expense of lower federal courts. What the new ruling does then is to give SCOTUS yet another tool by which to manage the lower federal courts and to intervene, perhaps to drag out proceedings by tinkering with remedies while not addressing the merits of a constitutional question. Well, is this good or bad to have this other tool? Well, I think it kind of depends on things that we don't yet know a lot about. But in my book, Practical Equality, I called these strategies of delay that we see in this case, strategies of deferral. And there are a few reasons why SCOTUS might wish to engage in strategies of deferral. First is when a question is deeply controversial, and it might be hard to reach a clear consensus on the issue within the court. Second, when the court might wish to avoid direct conflict with a co-equal branch. Third, when the court is inundated with legal challenges and wants flexibility to sift through cases and find the ones that truly require the justice to try to forge a consensus and weigh in. Now, the court has deferred difficult constitutional questions in the past. For example, they deferred the question of interracial marriage for decades, while the federal courts were occupied with the desegregation of schools and other public institutions. And we also saw strategies of deferral used by the Supreme Court of the United States to defer questions raised in challenges to criminal procedures. Now, I think all these conditions that I mentioned are true when it comes to birthright citizenship, which involves a signature issue of a populist president that has been returned to power by the electorate. Birthright citizenship today is a contentious issue in the political realm, even though it has long been a settled issue as a matter of Supreme Court jurisprudence. However, populists of all stripes, whether they come from the left or the right, seek to create legal vehicles to tee up opportunities for reconsideration of long settled questions. This is just a historical fact. This is true of abortion, and it has been true of the appropriate scope of the administrative state. And it also is true here in terms of efforts to get the Supreme Court to overrule or to narrow Wong Kim Ark and alter the court's interpretation of birthright citizenship. The court's not yet inundated with birthright citizenship cases, but they do have many legal challenges to a wide array of Trump policies. And surely the justices do not want to weigh in on all of them, which might make the court, already unpopular, even more of a target. So what might happen here? I think it's clear that the Trump administration wants clarity. They want the case overruled. They want to be vindicated. So do the three dissenters, the remaining liberals, in a populist age when what appears to be a settled constitutional question is now seemingly under pressure. It's not apparent yet, though, how many of the 6 conservative justices want to be on record when it comes to birthright citizenship. So the strategy of deferral for now denies the Supreme Court's imprimatur on an outlier constitutional interpretation and avoids what I've called tragic precedents while buying time. I think it would be a tragic precedent if, merely through judicial interpretation, a class of people living in the United States were once again categorically rendered non-citizens as a matter of fundamental law and potentially stateless. If there's no circuit split on this question of birthright citizenship below, the status of quo jurisprudence on 14th Amendment holds, and the remedies are carefully tailored to the parties in those cases, then perhaps the Supreme Court will stay out of this issue, knowing that Trump's executive order will be withdrawn the moment that the White House changes hands. This is not unlike his travel ban. That would allow the matter to be resolved through ordinary politics and avoid an ugly split on the court that might lead to the rewriting of the 14th Amendment by unelected justices. And don't forget, the executive order is forward-looking, applying to children born 1 month after it was signed. No one yet has been denied papers or blocked from reentry. No one, as far as we know, is undergoing a process of citizenship stripping under that executive order. Will the court intervene more often because of this decision to help Trump's agenda? I think it's too early to say. Ketanji Brown Jackson, in her dissent, worries about, quote, zones of lawlessness created. And Sotomayor also worries that you could have clear principles, but then violations of the principle. I think these concerns are valid, but what they're really just talking about is the problem of under-enforcement, which always exists to some extent. And in most circumstances, compliance with constitutional principles requires respect and voluntary action rather than judicial orders. Nothing in Trump versus CASA changes that, but it does highlight once again the importance of elections to ensure virtuous leaders and government employees who obey the courts. Under-enforcement can also be met through local and state politics and creative grassroots efforts. Here's a final thought on nationwide injunctions as I wrap up. I actually believe that reform would be worthwhile. And indeed, Amy Coney Barrett's ruling points to a problem of judge shopping. But reform should be done broadly and through Congress and not selectively by a handful of justices. This ruling raises more questions than it answers about how litigation proceeds going forward. As others noted, class actions and other avenues remain open, at least in theory, and they may be able to provide similar relief. This decision, though, does nothing about judges in single districts, nor does it end judge shopping, behavior that bedevils presidents of both parties. It also does nothing to make the exercise of judicial power more predictable or cut it down to size in a way that's beneficial for democratic decision-making. So if you believe in the need for more legislation to fix longstanding problems in society, you cannot be, I think, for either the status quo or the current state of judicial supremacy. Federal judges should not be allowed to so easily upset intricate legislation over things like healthcare or interfere with the legitimate administration of the laws. And I'll stop there. Thanks so much.